Hi, my name is Chris Mays. I'm a Northern Virginia estate planning and elder law attorney, and this is our on-demand webinar for guardianship and conservatorship in Virginia. And so the basic idea here is we'll take about 30 minutes or so and talk about the basics of guardianship and conservatorship in Virginia, right? We'll talk about what guardianship and conservatorship is. We'll touch briefly and sort of generally on the court process that's involved in guardianship and conservatorship. And then we'll talk about working with our office to represent you in your guardianship and conservatorship matter. So to begin with, let's talk about what we mean when we say guardianship and conservatorship. So you'll hear these words or different words used in different states, right? So this is a state law issue, so different states are going to have different laws, even though they all sort of tend to be similar. One of the differences, though, is going to be the labels, right, or the words that we use to describe it. So in Virginia, we talk about a guardian and we talk about a conservator, right? A guardian in Virginia is going to be a person appointed by the court who is responsible for the personal affairs of an incapacitated person, right? We're looking at the Virginia Code here. That will include responsibility for making decisions about that person's support, care, health, safety, medical treatment, and their residence. So that is guardianship in Virginia. When we're talking about a guardian in Virginia, we're talking about a person responsible for the care of another person. We'll usually call that person the ward or the respondent, right? In Virginia, when we talk about managing a person's financial affairs, that is the conservator, right? So if somebody is incapacitated, they're unable to manage their financial affairs, we can appoint a conservator to manage their finances. Keep in mind, the thing that we sort of see, the critical question here is going to be, is this person incapacitated? That's the standard, that's the point at which once somebody becomes incapacitated and a court determines them to be incapacitated, that is what allows the court to appoint a guardian and conservator. So if somebody's not incapacitated, right, the court has no ability to appoint a guardian and conservator. It's only when somebody becomes incapacitated we're able to do this. And we can do it so that somebody can be appointed guardian, somebody can be appointed conservator, somebody can be appointed both guardian and conservator. So we really look at the individual circumstances to see what does this person need? Do they need a guardian? Do they need a conservator? Do they need just one? Or do they need both? In other states, you'll hear terms like guardian of the estate instead of conservator. But generally, the concept of somebody being appointed to manage care, somebody being appointed to manage finances, that's fairly standard throughout every state. So if the question is a person incapacitated, right? If that's the point where we start to talk about guardianship and conservatorship, what does that mean? So again, we'll look to the Virginia Code, and we'll see that incapacitated simply means that someone lacks the capacity to manage their affairs, right? If we're talking about guardianship, then somebody lacks the capacity to meet the essential requirements for their health, care, and safety. They're unable to manage medical care. They're unable to manage their day-to-day personal care. That is where somebody becomes incapacitated for purposes of guardianship. Likewise, if we're talking about a conservatorship, a person is deemed to be incapacitated if they are unable to manage their property or financial affairs, if they cannot provide for their own support or for the support of their legal dependents, right? That's the point at which somebody becomes incapacitated. That's the point at which we now start talking about appointment of a conservator. So you'll also hear this idea of incapacity described as mental or mentally incompetent. That's another term, but the basic idea is for whatever reason, this person is not managing their affairs. Sometimes you'll hear people talk about, what particular diagnosis do I have to have? If I'm diagnosed with dementia, does that mean I'm incapacitated? Things like that. As we'll see here in a minute, certainly there's an inquiry into medical diagnoses, what is going on medically. But that's not the end of the inquiry, right? We really are looking at not just what your medical scenario or medical circumstance is. It's how does that medical circumstance impact your ability to do these things. So at the court, when we're looking at appointing a guardian and conservator, the court is really looking at, yes, you may have this diagnosis, you may have this evaluation, but what's the impact on your day-to-day ability to manage your own affairs? That's the point where we're looking at, okay, that's going to determine whether you need a guardian or conservator. There's plenty of people with a dementia diagnosis or some other diagnosis where just because they're diagnosed, they're still able to manage their affairs, therefore they're not necessarily appropriate for guardianship and conservatorship. So it's that day-to-day, how are your affairs impacted, how's your ability to manage things impacted, that's going to determine whether or not guardianship or conservatorship is appropriate. So when we do have a guardian appointed, what does that mean, right? So for starters, we call the person who the guardian is appointed for, we call that person the ward, we'll call that person the respondent. But that person, the ward or the respondent, will lose the ability to make decisions about their care and finances, right? Once a guardian or conservator is appointed, it's the guardian or conservator who has the legal authority to make decisions about care and finances. That respondent is no longer going to have any authority to do anything for themselves in terms of making decisions about their care or managing their finances. So it's a very serious impact. There's no real equivalent to that, right? So when we talk about like estate planning, we put powers of attorney in place to allow people to manage our healthcare and manage our finances. This is the key difference, right? With a power of attorney, you, as the person making that power of attorney, you still have the ability to withdraw the power of attorney, right? Or revoke the power of attorney. But with a guardianship and conservatorship, if that guardianship or conservatorship is appointed for you, you lose the ability to do anything for your own financial management or management of your care. So that can be a very serious consequence of guardianship and conservatorship. We also see that typically the respondent will lose their right to drive. Sometimes exceptions can be made, but oftentimes this is sort of the typical outcome of a guardianship. We also see that the ward or the respondent can lose their right to vote and their ability to possess or purchase firearms. Now again, the court has the ability to make exceptions in some cases, but more often than not, we're going to see the loss of these rights as a result of a guardian being appointed. The law in Virginia does require that guardians encourage the ward to participate in decisions, right? And the decisions made by the guardian or conservator reflect, to the extent possible, the wishes of the respondent. But we also realize that sometimes the respondent may not be able to effectively participate in those decisions. Nonetheless, these decisions should consider the personal values and expressed wishes of the ward, if at all possible. So let's talk a little bit about the court process for appointing a guardian and conservator. So this is a big overview. We're not going to get too far into the technical details, but this is just a quick overview of the process as a whole. So we can start here, just like most other court proceedings, a guardianship proceeding starts with a petition, right? And so the petition is filed with the circuit court, typically where the the respondent lives. That petition is going to describe what the circumstances are, right? Who the respondent is, what circumstances cause the filing party to believe that a guardian is needed, and what you're asking for. Are you asking for guardian? Are you asking for conservator? Are you asking for both? That petition will be filed with the court. It'll initiate the case with the court. Once a petition is filed, the court will automatically appoint what's called a guardian ad litem. So it's a little confusing. I'm not a huge fan of this term. You'll hear the guardian ad litem called the GAL, but a lot of people tend to think this is almost like a temporary guardian. That's not exactly correct. What the guardian ad litem really does is conduct an independent investigation into the case for the court, right? So the guardian ad litem is sort of like a neutral third party. They don't represent the petitioner, they don't represent the respondent, but the guardian ad litem does an investigation. They'll look at the respondent, they'll look at his or her medical information, they'll try to look into, does this person truly need a guardian and conservator? They'll look into why the guardianship might be necessary. They'll look into who the proposed guardian is, right? So is the person who we're looking at serving as guardian and conservator, are they appropriate? Are they going to be able to do the job? Or in some cases, a guardian ad litem may say, I know they're asking to be appointed as guardian conservator, but I don't know that they should be. Maybe we should consider somebody else. The guardian ad litem typically will make a written report to the court. That report will have recommendations about the guardianship as far as who should be the guardian, if a guardian is necessary, and things like that. The judge will review the report and consider some of the recommendations. The judge is not required to follow the recommendations of the GAL, but a lot of times, the court is sort of looking at the GAL to be the eyes and ears of the court. So a lot of times you'll see that the judges do tend to give a lot of weight to the guardian or GAL's recommendations. So once a guardian ad litem is on the case, we very quickly tend to discover that a case can go one of two directions, right? When we're talking about guardianship and conservatorship, you're typically going to have either what we call an uncontested guardianship case or potentially a contested guardianship case. And so the basic idea here is with an uncontested guardianship, there's no dispute that needs to be resolved by the court, right? There's no objection to a guardian being appointed. There's no objection to the person that is being appointed as guardian and conservator. Everybody involved sort of agrees, or at the very least doesn't object to all of these things. And so it's almost like a simple clerical matter of having a judge sign off on the paperwork to appoint a guardian. An uncontested proceeding can be very quick. Typically, once the GAL has done his or her investigation, we do a quick 5-minute court hearing. The judge will sign the paperwork appointing the guardian, and then we're good to go. So as you can see, with an uncontested guardianship, it's really more of just sort of an administrative process, getting the guardian appointed and sort of doing the necessary paperwork. That is a relatively easy way for guardianship cases to play out. The other side of the coin is what we call contested guardianship. So there is a right for basically anybody involved to contest some aspect of the guardianship. So for example, we can have the respondent, right, the person that we're looking to have a guardian appointed for. That respondent can say, I don't agree. I don't want a guardian or conservator appointed for me. that respondent has the right to request defense counsel be appointed, and the respondent can even request a jury trial, right? One of the things the guardian ad litem will do in his or her investigation is they'll talk to the respondent. They'll try to get a sense of sort of what their situation is, and they'll be required to ask if the respondent objects to the guardianship and if they want legal counsel. If the GAL learns that the ward or that the respondent does want legal counsel, then the legal counsel will typically be appointed. At that point, the respondent can object to and fight against the guardianship. So now the guardianship is what we call contested, right? There's a dispute about the guardianship. It can also be that there is a dispute about other issues as well. So maybe the respondent isn't objecting to the guardianship, but maybe there's a dispute about who should serve as guardian, right? Maybe the guardian doesn't want the person who filed the petition to be the guardian. Maybe the respondent doesn't want the person who filed the petition to be the guardian. What also happens in a guardianship case is that family members are going to get notice. So Virginia requires family to receive notice of a guardianship petition. So notice or copies of the guardianship papers will be mailed to members of the respondent's family. Those papers will say that everybody who is related, all the family members have the ability to involve themselves in the case and, argue for or against certain aspects of the guardianship. So sometimes this is where we see people come in and sort of one family member can say, I want to be guardian. Another family member comes in and says, no, I don't think you should be guardian. I should be guardian. So it can also be a dispute like that, right? Where we're not disputing the fact that there should be a guardian. We're disputing who should be the guardian. And again, if any of these issues are contested, right? If there's a dispute about any of these issues and we're unable to resolve it, then the way the court deals with the dispute is we have a trial. And that trial, it's just like on TV, evidence is presented, each side presents their case, and then the judge or jury makes a decision about the guardianship. Obviously, this is going to be, if we're looking at contested guardianship cases versus uncontested guardianship cases, if a case becomes contested, it's going to involve a much longer timeline, right? We're certainly not talking about a 5-minute hearing. Now we've potentially got a multi-day trial, potentially a jury trial. But also, we've got months of preparation. We may have experts involved. There may be witnesses involved. So things like that. So that's the overall big picture. And when we're looking at guardianship, that's sort of one of the things we want to quickly sort of ascertain is, do we think this is going to be uncontested, or is there a possibility that this could become contested? If so, there's two very different approaches to guardianship. One of the things that we'll see in a guardianship case, regardless of whether the case is contested or uncontested, at some point there's typically going to be an evaluation of the respondent. So this is something that is essentially required by the Virginia Code, unless there's some good cause for not having an evaluation. That good cause could be some sort of emergency or whatnot. But typically we're going to have a written report prepared by a professional licensed healthcare provider that says, I've assessed this person, I've diagnosed them with these conditions, and as a result of these conditions, here is how their functioning is impacted. A lot of times this evaluation will be done before the petition is filed. A lot of times we're going to file this evaluation together with the petition. In some cases, a petition can be filed before an evaluation is done, and part of the court process is asking for and getting that evaluation completed. But typically, I'd say most commonly, the way it is done, an evaluation is done first, and that evaluation then is filed with the petition to start the case. When we look at appointing a guardianship, as we saw, it's a very sort of severe action. It takes away essentially all of the rights of the respondent, and it places a lot of limitations on what they can do. So the law requires us to look at least restrictive alternatives, right? This is going to include things like, do they have powers of attorney advance directives? If so, why are we not looking to those to resolve these issues? Sometimes there are things like supported decision-making agreements, so we can bring in professionals to help us address particular issues. But we're always going to be looking at, are there ways we can sort of soften some of the extreme effects of guardianship and conservatorship? Likewise, we can place limitations on guardianship and conservatorship. So the court, as we noted earlier, can say, yes, I'm appointing a guardian, but you still have the right to do X, Y, and Z, right? You as the respondent can still do this, 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 and this. That tends to be less common, but it's still possible, and it's part of what we consider before we take the extreme step of appointing a guardian or conservator. So that's a quick overview of guardianship and conservatorship. I always tell clients it's a very, when we get to the point where we're talking about guardianship and conservatorship, there's a very serious question usually about somebody's care or finances. These are particularly important issues. So it's always good to get an attorney involved and get as much help as possible as soon as possible. So we make it very easy for you to talk to an attorney. Simply, you can go to our website and schedule a call that way. You can call our main number and schedule a call with an attorney that way. But always a good idea to talk to an attorney, get with an attorney so that you can deal with this as quickly and effectively as possible. So again, please feel free if you'd like to talk to us about your guardianship or conservatorship matter. We're happy to do that. Just schedule a call through the website or give us a call at our main number. Thanks.